So we have chapter 3 today, as I said last Monday. Chapters 2 and 3 are the basics for the whole course. So we need to know the concepts, things we go through in these chapters 2 and 3, so that we understand the course starting next week. Because starting next week, we'll go through several legal topics, different ones. So we'll go through tort, we'll go through contracts, we'll go through business organizations, etc. So in chapter 2, we had the definition of law, and then we categorized the law as public or private or substantive or procedural. We then talked about the civil law system that is based on the civil code for private matters in Quebec. And we spent a lot of time on the common law system. That is our focus. That is our objective, because BC and all over Canada, we have the common law legal system. You may remember that the main characteristic for the common law legal system will be stare decisis, the principle that says if the facts of a given case are similar to the facts of a past case, that past decision, also known as precedent case law, is binding. So the judge has to apply that. And today we're going to go through the court system. So this will be even more clear to you. And then moving on, we talked about the government or the system of government in Canada. And Canada started with the Constitution Act of 1867. You may remember that this is the Constitution Act that formed Canada as a country, divided the powers between provincial and federal governments. You may remember the criminal law example. You may remember the safe injection sites example here in Vancouver for provincial power. You should also remember the rule of law, conventions and statutes that are recognized in Canadian Constitution as valid sources of law. We then went through the Constitution Act of 1982, the most recent one. That is important because Canada became fully independent from the British, and also because it brought the Charter of Rights and Freedoms. And then we went through the branches, the executive branch, legislative branch, and the judicial branch. So the judicial branch, we know this is the court, they are the courts. And then legislative branch, they are the parliament at the federal level, and the legislative assemblies at the provincial level. And we have the executive branch, prime minister and cabinet federal level, premier and their cabinet provincial level. And all those three branches, they have to work in harmony, right? I told you that based on the Charter of Rights and Freedoms, the courts have given more power. Why? Because the courts now have the final say, the final word. So if either the legislative branch, when they make laws, statutes, acts, or the executive branch, when they make regulations, bylaws, if these, we call legislation, if they are not compliant with the charter, the courts will strike it down. The courts will say, hey, this legislation is contrary to the charter, so they are illegal. So you should also remember this. And then, if I'm not mistaken, we ended the chapter or the lecture by talking about the Charter of Rights and Freedoms. So I discussed with you some of the freedoms and rights. And it is very, very important to remember that the charter will be applicable for governmental actions. So when the government breaches our freedoms or violates on our rights, then we sue the government. We go to court. We sue the government so that that alleged illegal act is decided to be legal or not by the courts. I gave you an example of the health order. Remember, during COVID, gyms were closed. We could not have visitors in our home. So that could potentially be a violation of our mobility rights. I haven't seen any cases on those, but that's an example. We also discussed about freedom of expression. We discussed a little bit about a warrant. So you told me that you would not allow a police officer to come into your house unless they show you a warrant. So those are some protections we have from the Charter of Rights and Freedoms. And the other way rights are protected, it is one other way, it is through human rights legislation. So I told you that in BC, we have the Human Rights Code, and the human rights is not used for the government action, but for action from private entities, private individuals. So I told you that if Tim Hortons, if they have a job posting saying that only women should apply, you told me that this is discriminatory. And the answer is right. Yes, it is. But in this case, because Tim Hortons is private, it's not the government, you don't sue Tim Hortons. What you do, you file a complaint with the Human Rights Tribunal. So in a very nutshell, this is a summary of what we saw on Monday. So now moving on, we know this basics on substantive law. Now we go through disputes, the resolution of disputes. So today we're going to go through how disputes are solved in Canada, and it will be better for us to understand how the common law principles are applicable, how the past decisions, how the case law is applicable. But before suing someone, before litigation starts, not only before, but we should know that there are alternatives out of court to try to solve disputes. So parties have alternatives out of courts. But if those alternatives don't work, if parties are not successful with them, then the court is always there. The justice system is always there. No one is usually prohibited from suing the other. So let's say I want to sue Diego. I can sue him. Just now, I'm going to sue you. However, I have no grounds to sue Diego. So it may be the case I'll lose, but I can sue. What I'm telling you is, in principle, nothing prevents me from suing another party. But I will only decide to do so if I have grounds. If Diego caused me loss or anything else happens. Okay? So the courts, they are always there. Exceptionally, in exceptional cases, parties cannot go to the courts. Well, one exception is human rights, discrimination. So if you discriminate on me because I'm from Brazil, I cannot sue you. What can I do? Go to the human rights tribunal. Exactly. File a complaint with the Human Rights Tribunal, right? But this is the exception. And this is the exception because the politicians, when they passed the law, they didn't want discrimination issues to be solved by the court. They wanted a specialized tribunal, specific tribunal to be created so that human rights issues would be solved by them. Okay? That's the option of politicians. But in general, we can sue one another. But let's talk about the alternatives to court litigation or to court action. So they are negotiation, mediation, and arbitration. We could spend the whole 6 months, even more time talking about them. So I'll give you the very, very basics on them. And I'll start by saying that, first of all, these are options. These are alternative. In other words, no one can be forced to go through them. Okay? As a general rule, we cannot be forced. We have to agree. So that's the first thing. If we compare to litigation, so when I sue Diego, well, Diego has no option but to defend himself in court. But I cannot force Diego to negotiate the issue with me, or to have the issue mediated with me, or to go through arbitration. In other words, for parties to solve their issues through any of these, they have to agree. So there has to be an agreement. This agreement could be verbal, could be in writing. It's usually in writing. So I cannot force someone to negotiate with me. But we have to agree on this. And it's usually indirect agreement, mainly for negotiation. Mediation and arbitration, there's usually an express agreement. But for negotiation, well, for example, I am married. I negotiate with my wife on a daily basis. I lose all negotiations, but still, we negotiate on a daily basis, right? So it's common. In business, it's also common. So you bought products, and then the product had quality issues. Are you going to sue the seller right away? No, in principle, you call the seller or you write an email and say, hey, there were some quality issues. What can we do? Can you refund? Can you send other PCs? Or can you give me a discount in the next order? So that's negotiation. We do negotiation on a regular basis. In law, there's one aspect that is important. The solution for negotiation. The solution is not binding. Not binding, meaning parties are not required to follow the solution. They should, but they are not required. So when I tell you that I negotiate with my wife on a daily basis and I lose all, I'm fine, because I'm not required to follow. Okay? I'm fine, it's a joke. But it's not a binding solution because it is that parties have come to an agreement. Sorry, the parties have come to a solution. How can we make the solution binding? How can we make the solution enforceable? What do you think?
Writing an agreement after the negotiations.
Exactly. So you send products to me, I purchased products, the products had a quality issue. So we negotiated that the next order you will give me a discount of 10%. Because I know in law, you are not required to follow that. So I ask you to sign an agreement. Then the solution becomes a contract, becomes an agreement. If you don't give me the discount in my next order, I may sue you under the contract because you breached the contract. Okay, so that's important. Now, mediation. What is mediation? Mediation is similar to negotiation. However, there's a third party as a mediator, known as a mediator, trying to help parties reach a solution. So if I take you to a family example again, so let's say the issue with my wife is more serious now. We can't seem to find a solution on our own. So we go out there and try to find a counselor, a religious leader, a friend of ours, not my mother-in-law, but someone that is neutral to both my wife and I, and the mediator will help us reach a solution. The mediator does not make a solution, just help or tries to help parties make a solution. So that's mediation. And also, the solution for mediation is not binding. The same thing as negotiation. You could ask me, well, if the solution for negotiation and mediation, they are not binding, Why do they exist? Well, they exist because in most cases, parties follow what the solution is. And also because parties may then enter into an agreement based on the terms of the solution. Okay. Now, when we talk about arbitration, arbitration is the more adversarial of the three. Arbitration is more similar to litigation. It's not litigation, but it's more similar. Why? It is more similar because, first of all, the arbitrator is the one making a decision, similarly to a judge. The mediator does not make a decision, but the arbitrator does make a decision. So parties, the disputing parties in an arbitration, they will submit their evidence similarly as it is in court. Could be written documents, could be witnesses, evidence they have available, and the arbitrator will make a decision based on the evidence they have. Okay? The decision of the arbitrator that is called or is known as arbitration award, this decision is binding. Parties are required to follow the decision. Sorry?
What's the position called?
The decision is called arbitration award. So it's an award. AWARD.
E or D?
D, Donald. Yeah, arbitration award. So the arbitration award is binding. Parties, the losing party has to follow. What if they don't? The winning party will take their arbitration award and bring to court. And then the judge will order the losing party to comply. Because the arbitrator does not have such a power. The arbitrator does not have the enforcement power. But the judge will not reveal the merits. The judge will not start a new procedure. The judge will just look at the award and say, hey, do it. Comply as decided. Okay. One other thing I want to share with you is you don't have to go through all this. So you can go through any you want or even all. So there are some business contracts in which parties will agree to go through negotiation when they have a dispute. If the negotiation is not successful in certain amount of days, 30 days, 60 days, then the issue may be mediated. If mediation is not successful, then arbitration. But you don't need to go through all this. You can agree on negotiation and then go straight to arbitration. Or you can agree only on arbitration or only on mediation or only on negotiation. If negotiation is not successful, then court. So you can use any or all. One very important thing, very important. If you agree to arbitration, you cannot go to court. If you agree to arbitration, you cannot bring your dispute to court, to a judge. What I told you before is, if an arbitration award is not complied with by the losing party, then the winning party will bring it to court so that the judge orders the party to comply. This is one thing. But if you and I, in our business transaction, if we agree to arbitration for any disputes we may face, and then we have a dispute, I am not happy with arbitration, or I don't want arbitration, I want to go to court, I cannot. You cannot. When parties agree to arbitration, they cannot go to court. Why is this important? What is the consequence of this? You are waiving your rights to go to court when you agree to arbitration. So there's a quite recent decision from the Supreme Court of Canada. Uber drivers, when they sign the terms and conditions, they agree to arbitration with Uber if they have a dispute. And the arbitration for Uber disputes has to be in London, UK, not Canada. So this driver challenged in court the arbitration agreement. The driver came to court and said, hey, court. The driver came to court for a dispute with Uber, and Uber defended themselves saying, hey, our terms and conditions have an arbitration clause. And when there's an arbitration clause, the party cannot start a lawsuit. But the Supreme Court of Canada, in this specific case, they decided that the arbitration clause in Uber terms and conditions and agreement is invalid. Because it's difficult for a driver to solve their disputes in England. It's costly, and it's sometimes impossible. You have to reach lawyers there, pay in different currency, etc. So the court confirmed that when you choose an arbitration, you cannot use the courts. But the court also said that not all circumstances, an arbitration is the best method, is the legal method. Okay, so you can search online later on if you want to read more about this Uber Supreme Court case. Last comment on this. There's ad hoc and there's institutional mediation or arbitration. What is ad hoc? Ad hoc is here, decided by the parties. So let's say a student and I have a dispute. So we choose another person, just one that is walking in the hallway, and say, hey, can you be our mediator? Can you be our arbitrator? So this is an ad hoc arbitration or mediation. The institutional one is the one that is run, that is managed by an institution. Like in Vancouver, we have the VANAC, the Vancouver Mediation and Arbitration Center. So if parties agree to go through either mediation or arbitration at the Vancouver Mediation and Arbitration Center, they will then follow their rules. Okay, that's also part of this alternative dispute resolution. In general, arbitration decision, the arbitration award, non-appealable. You cannot appeal. You cannot have it reviewed in principle. But if it is an institutional arbitration, like here in the Vancouver Mediation Arbitration Center, you can appeal the decision. Okay, but it depends on what the institution is. In principle, not appealable. Well, as I said, there would be a lot more to discuss if we could and if we had time, but here's just to give you a glimpse, a very broad view on the alternative dispute resolution. Questions? Anyone? No? Okay. So you can just read this later on. We just discussed about this. So now we're going to talk about courts. So as I said initially, courts are always there for the parties. So let's say you rented an apartment from me. I am your landlord. You are my tenant. You didn't pay the rent. So I can bring you to court. I can sue you to recover my money. So court is always there. Or someone caused you loss. Someone hit your car. Someone stole something from you. So courts are always there for the parties. But you will only sue, you will only start a court procedure if you have grounds to do so, if you need to do so. Okay? So some principles for courts. First of all, procedures, they vary from province to province. Procedures vary. They are actually similar from province to province, but not the same because they vary. They vary in terms of name of the courts, timelines. So there are several aspects that are different here in BC, from Alberta, from Ontario, from other. So lawyers in Canada, for example, they are licensed to practice at a province. When I become a licensed Canadian lawyer, I will be probably licensed in BC, so I will practice law here. If I want to practice law in another province, I have to go through the license procedure of that other province. And I should know the name of the courts, documents, timeline, all procedures, because again, they vary by province to province. General rule, trials are open to the public. That's a general rule. Why general rule? Well, because there are exceptions. So the general rule, trials are open to the public. You can go to the BC Supreme Court here downtown, or you can go to the provincial court as well, and you try to see a hearing or a trial, to attend a trial. In general, they are open. But there are circumstances in which the trial is private. Examples will be when there are children matters, sometimes family disputes. So there are some matters that are, by rule, private. But in general, trials are open to the public. Okay? Even in the general rule, when the trials are open to the public, if a party wants, one of the disputing parties, if they want to have the trial private, they can request to the judge. Then the judge will decide on the specific case whether they will make the trial private or not. Okay? Let's say examples in which one company is suing the other and they are discussing about trade secrets. Let's say they don't want their discussion, their submissions about their trade secrets to be reviewed to the public in general. So those are circumstances. Example. Now let's differentiate a civil matter from a criminal procedure. So first of all, a civil matter. What is a civil matter? Remember on Monday, what I told you about civil. When we talked about civil law and private law. So I told you that civil, in that circumstance, was to be understood as private. So civil matters will be a private matter. A civil matter will be when two persons or two entities, two institutions, they have a dispute. And they use the court to have a decision for their matter. Can you give me an example about a dispute? Give me an example where you would sue someone or you would sue a company.
I got sick eating their food.
You got sick eating food. Yeah. So you had medical costs, you may have lost wages, etc. They don't want to pay you. You try to negotiate, but they don't want to pay you. So yes, you bring them to court and you sue them. That's an example. Okay. In a civil matter, the judge will decide on a balance of probabilities. This is an important concept. Deciding on a balance of probabilities means that one party is more likely right than the other. So when you sue a restaurant because the food you ate made you sick, the judge, based on the evidence you present to the judge, witnesses, recordings, receipt, doctor bills, etc., etc., based on the evidence you present, and also the evidence that the defendant, the restaurant in this case, present, the judge will decide on a balance of probabilities. In other words, the judge will decide more likely that the plaintiff, the one suing, is right than the restaurant, the defendant, or vice versa. When I say balance of probabilities, I am not saying certainty. I am not saying the judge is 100% sure the plaintiff got sick and suffered loss because of that food they purchased. What I'm saying is, it is more likely that the plaintiff is right, the restaurant is not. In other words, this burden, this level of proof is not so high, because there's a higher burden of proof that is for criminal procedure. In a criminal procedure, the consequence may be that the accused may spend some time in jail or may face a probation order. So the consequence for the accused is harsher as compared to the consequence in a private matter. Because the consequence is in such a way, the balance of proof, or the burden of proof in a criminal procedure is known as beyond a reasonable doubt. What does beyond a reasonable doubt mean? It means there can't be any doubt that the accused committed the criminal offense. If there's a doubt the accused committed the criminal offense, well, there was, let's say it was a murder, they found the dead body, they found the gun, but they couldn't find evidence that connects the gun to the accused. People may have seen, but there were no remains of whatever substance there is in a gun or in a bullet in the hands of the accused. So there's a doubt whether it was the accused or not. So in this case, an example, in this case, the accused would not be found guilty. The accused would be acquitted. Does anyone remember the O.J. Simpson case in the US? A little bit. O.J. Simpson was accused of murdering his wife. The family, I'm not sure if it was they had children or not, but the family sued them in civil courts for compensation. The judge decided on a balance of probabilities that yes, it was more likely that O.J. Simpson caused losses by the murder than not. So the family won. However, in the criminal procedure, because the burden of proof is higher, O.J. Simpson was not found guilty of murder. Because the prosecutor could not prove the case beyond a reasonable doubt. So do you see the difference? So it's easier to prove something in a civil matter, private matter, rather than in a criminal proceeding. Okay, so that's the message we should know. A second message is, in a civil matter, it is one suing another. It is the plaintiff suing the defendant. Right? That's what a private matter is. So as you said, you were sick, you had losses because of the food, so you sued the restaurant. That's what a private matter is. But in a criminal matter, it is the government pursuing the accused, not the victim. So if I were a victim of a robbery, as a victim, all I will do is to report to the police. The police will investigate, then we'll pass the case over to the prosecutor's office, and the prosecutor will then decide to lay charges on the accused or not. It is the government, not the victim. Okay, that's very important. So if I tell you that John sued Mary, is this a private matter or a criminal procedure? Private matter, because only in a private matter there is one suing the other. But if I say that the accused was not found guilty, is this private matter or criminal proceeding? Criminal, because I'm saying about the accused being prosecuted. Okay? One other thing. Let's say we go on a break, and during the break, your laptop is stolen. Is this a criminal offense? What is this criminal offense about? How do we call it? Theft? That's a theft. So it's a criminal offense. I just told you that as a victim, what do you do as a victim? You report to the police, right? That's the criminal part of it. Did you have any loss because your laptop was stolen? So you lost $1,000, $2,000, right? Worth. How do you recover this? How? Lawsuit. So you sue the accused. Your suing the accused has nothing to do with the criminal procedure for the theft. Because the criminal procedure for the theft is in the hands of the prosecutor. Does it make sense? The prosecutor, if they have evidence, sufficient evidence to pursue the accused, they have to. The law says they have to. Because a criminal offense affects society as a whole. So that's why the government tries to protect us. But with regards to your financial loss, the government doesn't do anything. You have to go after your losses. So you have to sue the accused. Does it make sense? Your laptop was stolen, but you were just visiting Vancouver. You are flying back tomorrow home. You will not sue, potentially. You lost. But it doesn't mean the accused, if found, will not be criminally prosecuted by the prosecutor. So I'm insisting how separate those proceedings are. Because one is related to the criminal offense. The other is related to money, monetary compensation. They are different. And when your laptop was stolen, it was only one conduct, one wrongful conduct. But that conduct gave rise to the criminal part and the civil part. Does it make sense? So that's important also to know. This is what I'm mentioning here, both criminal and civil action over the same conduct. Let's get to the court system. So the court system, again, you are not here to be trained to be lawyers, but you need to have an idea about the court system. So you know where we stand. Let's start from top to bottom. First of all, we are not dealing with the military courts here on the left. We're not dealing with the federal court here on the right. Not in this course. We will do this in law school. For us, we're dealing with the provincial courts here in the middle and the Supreme Court of Canada. Okay, so starting from top to bottom, Supreme Court of Canada, the highest court in the country. It is based or located in Ottawa, Ontario. There are 9 judges. They are actually called justices, 9 justices that will hear appeals from all over Canada. So all over Canada, there may be appeals to the Supreme Court, and their decision will be the final decision for that case. Whatever they decide is final. So back in 2004, when they decided that same-sex marriage is legal in Canada, that was a final decision. Okay? And based on the common law principle of stare decisis, we saw last Monday, all their decisions, they form a precedent all over the country because they are the highest court and because we are a common law system, right? This is very similar to the US. I would say the same, but I don't know there in detail. So very similar to the US. You may remember last year, this controversial decision on abortion rights. Back in the 70s, 50s or 70s, the Supreme Court of the US had decided that abortion rights, they are constitutional rights. So that decision affected the whole United States because it's the decision from the highest court. And then just last year, they changed their view. They now understand that abortion rights, they are not constitutional rights. They're in the US because they are not. States can decide whichever way they want. So some states allow abortion, other states don't allow abortion after this decision. Okay? But the important aspect here is that you should know that the Supreme Court of Canada is the highest court of the country, and all their decisions will form a precedent in the country. Okay? They are a review court. They are not a trial court. They are a review court. What this means is the trial starts here. So party A is suing party B here in the province. And then there will be an appeal. There may be a second appeal to the Supreme Court of Canada. So they will review the decision of the Court of Appeal or the decision of the trial judge. Okay? So they are not the ones rendering the first decision. No, their decision is based on a review from lower court's decision. So they will say whether the lower court's decision is right or not right. And then their decision is final. Simple example. I won a lawsuit here in BC. The losing party appealed to the Court of Appeal, and then they won the appeal. The Court of Appeal understood differently from the trial judge. Then I appealed to the Supreme Court, and then the Supreme Court said, yes, the Court of Appeal is right. The trial judge was wrong. Or they will say, no, the Court of Appeal judges are wrong. The trial judge was right. So they go one way or the other. But they were reviewing decisions. Is this clear? This is the same thing for the Court of Appeal. Provincial Court of Appeal. So each province in BC, they will have a Court of Appeal. So now here, from this part, let's just think about a province. Let's just think about BC. So we are focusing in BC here. So BC has a Court of Appeal. This Court of Appeal of BC is also a review court. They review decisions from the trial judge, from the lower court. Okay? Because the trial judge, they may make mistakes. They may make mistakes while interpreting the law, or they may make mistakes while applying a statute, case law, etc. So parties, they have an opportunity to have their matter reviewed. So the Court of Appeal, they function similarly to the Supreme Court of Canada with regards to being a review court. Here, 3 judges will review any given case. Okay? You can only appeal to the provincial court if you lost. If you win, you have no grounds to appeal. Why would you appeal if you won the lawsuit? Right? So the losing party is the one appealing. The appeal from the provincial courts to the Supreme Court does not always take place. There are few circumstances in which an appeal from the provincial court, which is already a review, goes to a second review. In other words, what I'm saying is the Supreme Court of Canada, they only, well, only is a bit strong, but I'm going to use only. They only review matters of national importance. So sometimes parties will try to send their appeal to the Supreme Court of Canada, and the Supreme Court of Canada will say, no, I will not hear your appeal. In those circumstances, when the Supreme Court does not hear the appeal, or when the party does not appeal to the Supreme Court, the decision from the Provincial Court of Appeal is final. Does it make sense? And in those circumstances, the decision from the Court of Appeal creates or may create a precedent. But now this precedent is only applicable within that province. Because a decision from a Court of Appeal of BC is not binding in the court judges from Ontario. The judges there, they may use the decision from BC as a persuasive decision, as a decision that helps them decide their own case, but they are not required to. Differently from a judge from a lower court from BC. A judge from a lower court from BC, they are bound, they are required to follow precedents from the BC Court of Appeal. Is it making sense? So we're coming from top to bottom. Now, the trial courts. And I said trial courts because there's more than one court at the trial level. So I won't be focusing on criminal matters or tax matters. I'm just focusing on business matters and monetary amount, okay, for us here. So if you have an issue, if you have a lawsuit that is over $35,001, you start the lawsuit at the Superior Provincial Court. Over $35,001. If your matter is below $35,000 or up to $35,000, you start at the provincial court. Also known, or in the division, known as small claims court. And the small claims court, they vary from province to province. In Ontario, if I'm not mistaken, their limit is up to 50,000, 50, or 60. I think it's 50 now. But the amounts may change from time to time. I know in BC now, today, the limit is up to $35,000. Okay. So what is the difference between the Superior Court and the Provincial Court, the small claims division? Well, in the small claims division, the procedures are more simple. Parties can represent themselves. They don't need a lawyer. So it's simpler. You can do on your own. So you save money. But that's why they limit the monetary amount. And to make it even easier for people, more accessible to people, they have created what they call CRT, Civil Resolution Tribunal. So the Civil Resolution Tribunal is an online tribunal. You can start a lawsuit by internet at home. So you log on, you describe the facts, the issue, you provide the contact details, full name of the other party you have a dispute with. They will try to hear the other party and they will render a decision. It's even easier than the small claims court. So you should know, we should all know that matters, private matters up to $5,000, we start at the CRT. Civil Resolution Tribunal. From $5,001 to $35,000, we then use the small claims court, as I just said. There, small claims court. And if it's over $35,001, then the Superior Court. So coming back to the chart, up to 5,000 CRT, up to 35,000 small claims, over 35,000 Superior Court. In BC, the Superior Provincial Court is called the BC Supreme Court or the Supreme Court of BC. But you should not confuse the Supreme Court of BC with the Supreme Court of Canada. They are different courts. So, again, the lawsuit starts here at the lowest level, just divided or depending on the monetary amount. There are other matters. There are some matters that cannot be dealt with in the CRT. That are, let's say, family matters or... So I'm just giving you the monetary amount division. But in law school, we studied this in more details and etc. But here, I'm not going to those very details. Okay? So my questions to you would be, which is the highest court in the country? That's right, Supreme Court of Canada, the highest court in the country. What is the highest court in the province, in BC? Court of Appeal of BC. That's the highest court in the province, in BC. What is the highest trial court in BC? Superior Court. Or, as we know the name, the BC Supreme Court. So we talked about the highest trial court, the highest court in the province, the highest court in the country. Are we good? We also have the administrative tribunals. The best example is the Human Rights Tribunal. They are not part of the court system, but they function similarly because they render decisions, but they are not part of the court system. So I started going from top to bottom, now from bottom to top. I start the lawsuit here. Whoever loses, they don't have to, but they may appeal. There will be a decision here if the appeal is allowed. If it's a matter of national relevance, the losing party in the appeal may even appeal once again, or may appeal to the Supreme Court of Canada. If they accept, they may render a new decision if they believe that the lower decisions were wrong, or they may keep the same decision. In any circumstances, their decision will always create a precedent. The decisions of the Court of Appeal may create precedents within the province. Are we good? Yes.
Can I party appeal directly, maybe like Supreme Court of Canada?
No. So you start your lawsuit here, and then if you lose, you cannot go all the way to the Supreme Court. You have to go to the Court of Appeal. And then here, if you still lose, or the other party lost and you won, they can try to appeal to the Supreme Court. But I say try, because if they believe that it's not a matter of national relevance, maybe they will say, no, you cannot appeal further. Okay. Any other questions? Comments? All right. So let's break. Let's break for 12 minutes. Let's make it 5 to 3. Please. All right. So let's resume. I'll resume with a question for you. So, question for you to practice. Which one is right? Which one? A? B? Do you agree, A? Do you have a different answer? Come on, do you agree? A? Different one?
B.
Which one?
B.
D, Donald? B, Bob? Okay. So let's look at this together. The court system must be satisfied it was more probable that the accused committed a crime than not. More probable, balance of probabilities. Does balance of probabilities apply to criminal offense? No, it does not. What is the burden of proof here? You remember? Which one? Beyond a reasonable doubt. Okay, and why do we know the first one is a criminal offense? Because it's talking about a crime, because it's talking about the accused. Okay, so A is not right. B, the court must be satisfied that the plaintiff's position is correct on the balance of probabilities. Is this civil matter or criminal matter? Civil. How do you know it's civil? There's no accused, no crime. What else? It says plaintiff. Exactly. So we know this is a civil matter. What is the balance? Sorry, what is the burden of proof for a civil matter? Balance of probabilities. So B is correct. C is saying a jury can only be used in a criminal matter. This is wrong. We'll see in a minute. Can be used in civil matters as well. A victim is the plaintiff in a criminal matter. No. Remember, there's no plaintiff in a criminal matter. The victim has no role in a criminal matter except to report the criminal offense. The prosecutor is the one pursuing the accused. And E, the victim of the crime is the one who prosecutes. No, it is the prosecutor. It is the government that pursues. Remember? B is the correct answer. Are we good? All right. So moving on, let's talk about this concept known as limitation period. So limitation period, without going too detailed, limitation period is a time limit that the victim can start a lawsuit. So in the example where you get food and you get sick and you suffer losses, you want to sue the restaurant, you have a time limit to sue the restaurant. If you take longer than this time limit, you cannot sue anymore. So this is known as the limitation period. General rule for us in BC, general rule, 2 years. So you can only sue the other party up to 2 years after the incident that caused you losses. After 2 years, you can start the lawsuit, but the other party, the defendant, they will present a defense saying that the limitation period is gone. So the lawsuit is dismissed. Okay, that's a general rule. Because for human rights complaints, for example, 1 year. Employment matters, 6 months. You don't need to know the exceptions. You just need to understand what the limitation period concept is. And the general rule is 2 years here in BC. Another concept is jurisdiction. Jurisdiction is also known as the court, the place where the lawsuit will start. So we say, what court has jurisdiction? So if you are to start a lawsuit against a restaurant, where do you start a lawsuit? In BC, in Ontario, in Alberta. If you want to sue a tenant of yours, if you want to sue a company, where do you sue? So to find out where we sue, we look at the jurisdiction rules. The general rule is that the place of residence of the defendant is where the court will have jurisdiction. So the court of the place of residence of the defendant, not the plaintiff, the defendant. In other words, if anyone or any company wants to sue you, and if you live here in Lower Mainland, it is the Lower Mainland courts that have jurisdiction to hear the lawsuit. So no one will sue you in Alberta. No one will sue you in Ontario. In principle, I'm talking about the general rule. There are exceptions. There are exceptions such as the place of the accident. So let's say 2 BC residents, they were on vacation in Banff, Alberta, and they were involved in a car accident. And one is going to sue the other. Even though both live in BC, the lawsuit would be in Alberta because it's the place where the accident took place. Or the location of the real estate. So if you have a farm in Manitoba, but you live in BC, someone wants to sue you because of the farm, the lawsuit has to be in Manitoba, not here, because the farm is located in Manitoba. Again, you don't need to know those exceptions. I'm just giving you as examples. General rule, the place of residence of the defendant. Okay, that's what jurisdiction is. All right, now we go through the process of civil litigation. And what I will do is I will play this video with you. Considering I'm not a licensed Canadian lawyer yet, I haven't gone to a trial as a lawyer, so I found this video that is very informative to share with you. Again, for exams, you don't need to know the details of the process, but you need to understand what the trial is, what the civil litigation process is. Okay, so please pay attention to this.
Litigation, the conduct of a lawsuit, is a process. Legal shows on television that suggest that it's a process that begins and ends in 45 minutes. The reality is quite different. Litigation in British Columbia is a process with 10 stages. From start to finish, it takes approximately 15 to 18 months. The goal for our clients is to achieve the best settlement we can, without taking our clients through the entire 10-stage litigation process, ending up with a trial. The first stage is the pleadings. Pleadings include the notice of civil claim. That's the statement in writing of the plaintiff's case, the plaintiff's story. There's also the response to civil claim, which is the story of the defendants. We then move to the next stage in the litigation process, and that involves the discovery of the facts. The discovery stage has two components. First of all, discovery of documents. What that means is each party has to disclose, and the other side has to discover the other side's documents. In this day and age, the documents can be hard copy, they can be documents of emails, text, or any other form of digital writing. So there's a list of documents of the plaintiffs, and there's a list of documents of the defendants. The second component of the discovery process is the examination for discovery. It's an opportunity for both sides to have their witnesses tell their story. They involve a representative of each side with their own lawyer being examined by the lawyer for the other side. At the end of the examination or discovery process, everyone has a better sense of what their case is about and what the other side's case is about. And that very often leads to a discussion about settlement, and quite often leads to settlement itself. If one or other side is not disclosing the documents that are required, you go off to court to get an order that they do so. Without going into great detail, there are a number of different applications one might have to make to a judge along the road, and these are called interlocutory applications. There's always an opportunity for an early resolution of the litigation based upon what's transpired during the course of the discovery process. And that early resolution is called a summary trial. This is not the trial itself. There's no live evidence. You go before a judge to say the case is so clear based upon admissions obtained at discovery that this litigation ought not to go to trial. It can be resolved at an early stage. Witnesses can be lay witnesses. Those witnesses who are privy to the actual facts, who can give evidence about what happened on a particular day with regard to a particular transaction, etc. There are also expert witnesses, forensic accountants, appraisers, business evaluators, and the like. Finding the witnesses, interviewing the witnesses, determining the evidence that needs to be led at trial is the next stage in the process. A fair amount of time is devoted by lawyers to the preparation of the legal submissions, the legal arguments for the judge at the conclusion of the evidence. In the month before trial, the lawyers sit down with the various witnesses. We prepare not only our examination in chief, which is the witness's story, but also the cross-examination of the opposing witnesses. Civil litigation often settles on the courthouse steps. By that we mean the Friday afternoon or the Saturday or the Sunday before the trial that starts on Monday. Both sides generally recognize that there's an advantage to achieving a negotiated settlement that's acceptable to them rather than going to trial. But in those cases where a negotiated settlement is not possible, the trial does proceed. On day one, both sides plaintiff and the defendant make their opening statements to the judge. When that's concluded, the plaintiff then starts to lead its witnesses. Each witness is led in chief, in which they tell their story. They're then cross-examined by opposing counsel. There's also an opportunity for some re-examination by plaintiff's counsel if necessary. The defendant leads its witnesses in chief. They're cross-examined. There's potential for re-examination if necessary. And at the conclusion of the defendant's witnesses, the evidence, the evidentiary part of the case is now complete. What follows from the evidentiary case is the legal submissions. That's both lawyers, one for the plaintiff, one for the defendant, putting forward the legal submissions based upon the evidence that's just been heard by the judge. The judge then goes away for what could be a month, 2 months, sometimes as many as 3 or 4 or 5. And that's a good thing. That means that the judge is giving your case the fullest possible consideration and coming to the right outcome. Litigation is not for the faint of heart. It's an adversarial process.
Can stop here. So as I said, you don't need to memorize details. So in a very nutshell, that's how the litigation process is in BC. Questions? Do you have any questions on the video? Any steps you would like me to detail or comment on? I have shared the link of this video on your Learning Hub as well, if you want to watch it again. Okay. All right, so if you have no questions, let us continue. And I have discussed about this. So let's talk about the judgment itself. So the video talks about the judgment. And as we just saw in that question, review question we had, there can be a jury for a private matter as well. It's very common for criminal matters, but in civil matters, it's usually common for judge alone, no jury. Because if there's a jury, parties will have more costs, more legal costs, but they can if they want. So what happens? How is the judgment made? How does the judge arrive at the judgment? When there's a jury, the jury will decide questions of fact. And after the jury decides on the questions of fact, then the judge will decide on the questions of law. So what are questions of fact? Is it raining outside? This is a question of fact. Is it raining or not? When the accident happened, was the driver drunk? This is also a fact, yes or no? Last year, you may have seen on YouTube or in the news, John Depp's defamation lawsuit against Amber, I believe. So the jury decided on a question of fact. Was the statement defamatory? Was the statement false? The jury decided yes, it was false. Then the judge decides on the questions of law. Then the judges apply the law, applies the legislation, applies the case law, how it has to be applied. Does it make sense? When there's no jury, and in most common lawsuits, there's no jury, the judge will decide on both questions of fact and questions of law. Right? And when there's a decision, we call this the trial decision. So there's a decision of the trial. And then when I told you that the Court of Appeal and the Supreme Court of Canada, they are review courts, I meant, or we must understand that they will review questions of law, not questions of fact. Because questions of fact, they have to be decided at the trial level. And then when there's an appeal, the appeal judges, they will decide on questions of law. They will decide whether or not the trial judge apply the correct legislation, apply the correct precedent, or even if they apply the correct precedent, if they had interpreted them accurately or as they should. So those are questions of law. So next week, when we talk about the tort of assault or battery, and then we'll discuss about self-defense. I'll tell you that self-defense is usually a question of law. Whether your aggression to an aggressor was reasonable or not is a question of law. The judge will decide. Right? So this is important. Now, with regards to costs, well, usually the losing party in a lawsuit will have to reimburse the legal costs of the winning party. Usually, so the judge says, hey, you party A, you win, and party B, you lost the case, and you have to reimburse the legal costs with interest to the party A, to the winning party. Usually, there may be circumstances in which the judge will split the costs, but that's not so common. May happen, but that's not so common. Question for you. So these are all questions of fact, except one, that is question of law. Which one is this? Which one is the one with question of law? Remember, don't be afraid to make mistake. It's a safe place and we're practicing, we're learning. Which one? D. D, Donald, is a question of law. E, Eagle, question of law. What else? D and E? Any other?
No, E.
E? Okay, let's do E then. James claimed that Joe called him nasty names. Then James sued for slander. Slander, defamation, we'll see next week. Joe says that he did not make negative statements. He's claiming that his statements were all true. Whether a statement is true or false, is this a question of fact or law? Question of fact. It's a fact whether it's true or false. Okay, not E. D. James owed Joe money and Joe claimed he had paid it back 2 years ago. Well, did Joe pay or not? Is this fact or law? Fact. Okay, so not those two. Out of the three here. A. Okay, let's do it together. James was accused of fighting and causing injury to Joe, but James claims that Joe was the aggressor. Who was the aggressor? Question of fact. James and Joe were in an automobile accident, and Joe claims that James was speeding. What was the speed of the car? Is this question of law or fact? It's a fact. It's a number. All right, so the answer is C. Why? James and Joe were in a fight where Joe claims he was justified. This is the key word. He was justified in hitting James because James yelled at him and called him nasty names. Whether he was justified in hitting or not is a question of law, because it seems to be self-defense. Because they were in a fight, but the fight only started because James yelled at Joe and called him nasty names. Right? But whether this justification is legal or not, this is a question of law. Are we good? Okay, not an easy one, but it's good to practice in class. Okay, so C, the right answer. Remember those questions you don't have in your slides on Learning Hub, so you're most welcome to take a picture if you want to. All right, moving on. So moving on, we have, you want to take a picture? You got it? Okay. So moving on, we now have remedies. Well, we're talking about private matters, civil matters. In most cases, a plaintiff will sue the defendant because they want money. In most cases, not all, but in most cases. And money, monetary compensation in law, they are called damages. And we have several types of damages, but here we're just focusing on 3 of them: general, special, and punitive. And you must know all these 3. So I'll start with the special. Special damages are the costs and expenses you suffered, you incurred. So the food that you ate and that sent you to the hospital, you lost work. How much did you spend at the hospital? So these are general damages. Sorry, special damages. Okay, the costs you actually had. You can show receipt to the court, or you can prove with witnesses, etc. Then the general damages, they are future, not precisely calculated damages, such as pain and suffering. So you can try to remember pain and suffering. Well, after I got sick with the food, I developed some anxiety, some mental anguish, or any other mental issue that I cannot precisely calculate. So in a lawsuit, or this lawsuit example, I would seek special damages, and I could also seek general damages. So what I'm saying to you is that usually I will seek special damages. But it may be the case that on the top of special damages, I will be also seeking general damages. Punitive damages. So these are damages in which the court is trying to punish the wrongdoer, is trying to punish the defendant. So the example here, I have McDonald's in the US. So back in the 80s, this lady was in the passenger's seat. They purchased coffee through that drive-thru, and then after they left the drive-thru, the hot coffee spilled on her lap.
33 burns.
Sorry?
33 burns.
Yes. So evidence showed that she had 3rd-degree burns. Coffee was double the temperature, hot temperature, as compared to the temperature we usually prepare coffee at home. So she sued McDonald's, and she was awarded 1.3 million compensation. So there was certainly special, general, but also punitive damages.
I recall that she originally just asked for compensation for hospital fees.
Sorry?
I recall we originally just asked for compensation for hospital fees.
The 1.3?
That was how it's ended up, but that's not what she originally requested. That was just the compensation for hospital fees.
Yeah, she was seeking special damages, but the court ended up also awarding punitive damages. Okay, so the court wanted McDonald's to learn a lesson. Not only McDonald's, but the whole hot drink industry. With such award, the court wanted to teach the hot drink industry that they could not fill up the cup to the top. There should be disclaimers, caution, hot. They should train their employees. And the temperature should not be as hot as it was. So in other words, punitive damages, the aim, the objective is not to compensate the victim. Compensation for the victim is aimed at the special and general damages. Punitive is to punish the wrongdoer, the defendant. Okay? So that's how punitive damage is. There are other remedies such as accounting, injunction, specific performance, declaration. So we'll talk about those other remedies as we move forward in the course when we go through torts, contracts. For now, I just want to talk a little bit about declaration. So when we discussed about the health order with regards to the charter. So the health order 2 years ago, gyms were closed. If I were a gym owner, I would sue provincial government. But in principle, I would not be seeking money. I would be seeking a declaration from the court that the health order is illegal, is contrary to the Charter of Rights and Freedoms. So in some circumstances, even in a private matter, I won't be seeking damages, but I will be seeking other types of remedies. Okay, so in this case, I'm just exemplifying declaration. But the other ones I will exemplify as we move forward with the course. Are we good so far? So I expect you to remember the definition of special damages, definition of general damages, definition of punitive damages. Okay? You should know this. All right, now enforcement. Well, you sued the restaurant because you were sick with their food. You won $10,000. What if the restaurant doesn't pay you? Can you threaten them to pay you? No, you can't. What you will have to do is you have to use the court to help you get paid. In other words, it's not because you won a lawsuit that you will be paid. What if the restaurant goes bankrupt and they have no money? In other words, there's no guarantee we'll be paid if we win a lawsuit. What if you sue someone who has no work, has no assets? You may win, but you don't get the money. Okay? So before suing someone, you should consider carefully whether you will actually be successful with the lawsuit or not. So this part is called enforcement. So once you have a favorable judgment and award, if the losing party doesn't pay you voluntarily, you have to enforce the judgment. And to enforce, you ask the help of the judge. So what will the judge do? Usually, there will be an examination, as they call, technically speaking, examination in aid of enforcement. So this means that the losing party will come in front of the judge and they will be interviewed by the judge. Do you work? do you have assets? And then if they work, if they have assets, the judge will then seize their assets and offer for sale. The proceeds of the sale will be used to pay the award. If you have no assets, no money, can you go to prison? No, you can't. In Canada, you don't go to prison because you cannot afford to pay a judgment award. There may be countries where you go in some specific situations, but not in Canada. Okay? So, as an overall view, that's what the litigation process is. Now let's talk about this specific type of action, this specific type of lawsuit that is known as class action. What is a class action? Well, first of all, this is very common in consumer transactions. Why? Because a class action is related to a common issue, a common problem. What is a common problem? Example. Do you remember some years ago when Samsung tablets were catching fire out of the blue? Isn't this a common issue for all buyers of Samsung 7? When a car manufacturer issues a recall, isn't it a common issue for all owners of that type of car? So, a class action is when there's a common issue for an identifiable class of people. So all owners of Samsung 7 or all owners of BMW, Porsche, Lamborghini, whatever the car is. So how is the class action? Well, a person that was affected by that issue, they start a lawsuit on their own, but they ask the judge to classify that individual lawsuit as a class action. And they inform the judge, they try to convince the judge that it is a common issue that has affected an identifiable class of people. The judge will decide to grant class action certification or not. Once the judge classifies it as a class action, all other people who suffer the same issue, they have the right to opt in that class action. They cannot sue on their own. Because actually the class action objective is to avoid inconsistent results. If I sue Samsung, someone else sues Samsung in Ontario, other sues in Manitoba, other sues in Northern BC, different judges, there may be different decisions. So the class action idea is to avoid inconsistent results. So last year I got an email. I was a member of that car share. Remember the small blue Smart? Mercedes Smart? There was a car share program with them. Which one?
Is that Evo?
No, Evo is the one with the black cars now. I forgot the name of, but it was actually not last year, some 3 or 4. Car2Go, yes. So some 3-4 years ago, I was a member of Car2Go, and there was a class action against them because they charged one fee that they could not have charged. So because I was a member, I got an email saying that there was a class action. If I wanted, if I had the receipt of my trips, I could opt in that class action. But I'm telling you, it's about opting in or not. I don't have to. I just didn't want. I didn't have the receipts, or I didn't want to bother. It was about, I don't know, $5, $10, $15. So I don't have to, but I may if I want. Okay. So that's how a class action works. And it's not uncommon for class actions to be settled. So usually there's no trial. Why? Because companies, they don't want the bad reputation of going through trial, exposing their mistakes, their issues, there's manufacturing problems, etc. So they usually settle. Maybe you can research online later on. There were those guys in the US. They went to Subway and they purchased a 1 foot long sandwich. They measured, it was not on 1 foot. They went to another Subway, the same thing. Another, the same thing. So they started a class action, a lawsuit, and asked classification as a class action. And it was certified. And they were successful in the lawsuit. You can research later on. So it's common in consumer transactions. The example I have here for you is on a recall. So recall here in Canada, BMW owners. Again, if you owned one of these cars, there was a class action, you could opt in if you wanted or not. So it's just an example. If you want to search the class actions in Canada, you can use this link. Yeah, the link should be updated so you can search it there. So now the last part, before I let you go. So we're going to talk about regulatory bodies and administrative tribunals. So what is an administrative tribunal? Example, Human Rights Tribunal, Workers' Compensation Board, Employment Board. What are they? They are decision-making departments that function similarly to courts because they render decisions, but they are not part of the courts. And again, why not? Because it was the decision of the politicians to decide on the creation of a specialized, specific tribunal for that matter. Okay? They didn't want the judges to be dealing with this. So that's what an administrative tribunal is. What is a regulatory body? A regulatory body is a body that grants something or denies. So let's say if you are a pharmaceutical company and you want to introduce to the market a new vaccine. Can you introduce the vaccine freely, or do you need the authorization of the government? Authorization. In Canada, who authorizes a new vaccine, for example, or a new drug, a new medicine? I think CDA is in the US, Ministry of Health, on their department, Health Canada, it is called. That belongs to the Ministry of Health. So Health Canada is an example of a regulatory body. Because as a pharmaceutical company, I apply for authorization and they grant authorization or they deny. But there's another example for regulatory body. If you apply for a patent, you apply at the patent office. Patent office grants patents or not. So they are also an example of a regulatory body. If you want to start your own business, do you need a business license? Where do you apply for a business license? Just if you know. City Hall. City Hall is an example of regulatory body. So the principles we're discussing now, they apply to both regulatory bodies and administrative tribunals. Okay. So what are principles we have to discuss? Well, first of all, we need to understand the advantages of them. The advantages mainly for tribunals is because, as I said before, they usually have specific expertise in the matter. They are specialized in that matter. They are, because of this, they are more efficient, they are quicker and less costly. Actually, if you need or want to file a human rights complaint, you don't pay legal fees. You just file. But if you want to start a lawsuit, you may have to pay legal fees. So more efficient, less costly. The decision of the administrative tribunal is usually not reviewed by the courts. See, I'm saying usually, I cannot say never review. No, there may be cases where courts may review. What I'm saying is, if you file a human rights complaint and the human rights complaint decides that your complaint should be denied, should be dismissed, because it lacks grounds or merits, you cannot have the decision reviewed by the courts. That decision is final. Some specific case courts may review the merits, but this is a bit more complex. What courts will do, however, is to review the process of the decision. And how do they do this? Courts, they review the decision based on what they call procedural fairness in tribunals or in regulatory bodies. So if you believe that the decision-making process was not fair, you may bring it to court. So when you bring this review to court, courts will first look whether the decision maker had authority, had power to make a decision. This is related to the law, the act, the statute. And then courts will also look at the fairness of the process. And here it is really important to remember what the rules of natural justice are. These are rules that talk about a fair hearing, decision being made by whoever hears the evidence, impartiality, no bias of the decision maker. So if any of these rules of natural justice are breached, are violated, the courts may review the decision. The courts will say, hey, this decision, the decision maker was biased. So they cancel the decision and they order the tribunal to render a new decision. Different decision maker that is not biased. So they will do this. This also applies to companies, private institutions. So let's say here at BCAT, I as an instructor, let's say I state that you cheated in your exam, or you were you plagiarized in your, you don't have assignment, but let's say you committed plagiarism. You have a right, even at BCAT, for a fair hearing. You have a right that the person who makes a final decision is not biased, is impartial. In a company, if you are accused of harassment, theft, anything, we are entitled to those rules of fairness of the process or rules of natural justice. And then, as I said, reviewing a justice, usually most cases, the courts, they will not review the decision, but the process, as I said, and then they will look at this. Was the statute invalid or not? Was the remedy beyond the power? Were there any errors in the law? And the procedural fairness or natural justice rules. So they take this into consideration. All right, so that's what I wanted to share with you in chapter 3. So we talked about ways to solve a dispute in Canada. We can solve disputes out of courts, negotiation, mediation, or arbitration, or through courts. And then through courts, we went through the process, the court hierarchy, remedies, enforcement of judgments, remedies, etc. Questions? Any comments? What's your homework? Yes. So you have quiz. And the review question.